We have the opportunity to talk with Matt Garretson. He's an attorney with a national practice whose offices are in Cincinnati, Ohio. Matt, thank you very much for joining us during the convention. We've been hearing a lot about the use of the 468B trust.
Yes.
One of the things that I'm learning about from you is that the 468B trust has some tremendous advantages in dealing with the nightmare of the Medicare and Medicaid liens and the lawyers trying to figure out how they're going to affect the client once they get a settlement. Could you explain that?
Yeah, absolutely. We've, over the last 3 years, our firm has really seen a lot of progress on how liens are resolved. We, as you may know about our practice, I do a lot of special master work and complex litigation, and our practice has evolved to one of now just focusing on the resolution of healthcare claims, reimbursement claims associated with mass torts. What we've found is rather than dealing with these liens in the traditional one at a time as an afterthought after a case settles, that it is much better for all the parties, the defendants, the plaintiffs, and the plaintiffs' attorneys, if we address them in mass, in a group, and create some consistency and standardized approach to dealing with them from state to state for Medicaid, and of course with the federal government with respect to Medicare. Last year we evaluated and resolved over 30,000 liens in our shop related to FinFin and Zyprexa, Reslin, PPA, and that's the approach I would recommend using in this 468B trust, is being able to go to all the state agencies in the federal government and say, we speak as one, help us address what's related and what is not related to the injury, what should be on a claim and what should not, and let's resolve these as a group. And have it done in advance of the settlement rather than 6 months, 12 months, or maybe 2 years after the settlement, as many lawyers have seen with some of the earlier mass torts.
Yeah, I would like to explore that a little bit for the lawyer who's unfamiliar with the 468B trust and this particular application. Contrast it for that lawyer. Why is it a better alternative than what they're used to now?
Well, if you look at what's happened over the last year, we've had the, well, starting 2 years ago, we've had the Medicare Reform Act. Then we had the Alborn decision last year, the US Supreme Court decision. We had the Sereboff decision. Both those having a tremendous impact on how liens should be addressed. We've got the new Medicare Part D program that just rolled out. And we have the change to a new single national recovery contractor with regards to Medicare liens. All of that has made this so complex that if the way lawyers handled liens in 2006, all those rules are out the door. It's a new set of rules. And so, again, if we can aggregate all this together and be able to go and steer all these cases at once through that maze of changing rules and protocols, I think everybody is going to benefit tremendously.
Now, your firm has really developed an expertise in dealing with the regulators concerning Medicare and Medicaid liens. Yes. And this is a highly specialized area of practice that your ordinary practitioner is just not going to be familiar, nor are they going to have the time and attention or opportunity really to master or replace the experience your firm has. Are there, aside from your firm, are there any other firms that have that kind of expertise? And because it seems to me that your firm has really developed a very unique expertise in this area.
Not that I'm aware of. I mean, what's made us unique is we've had the background of working with medical professionals in our capacity as special master, and basically what we've done is taken that same skill set from settlement allocation and applied it in the field of lien resolution. So, for instance, in Zyprexa, we've got endocrinologists and diabetologists from Harvard working on the project. We have epidemiologists from renowned universities working on the project. And again, that's the beauty of aggregation in this context, is we can go out and retain the best experts in the country to deal with lien resolution, something that most people thought of as an afterthought. I've got Harvard experts talking to the Centers for Medicare and Medicaid Services about the causal relationship of certain ICD-9 codes or DRG codes to the drug product. That's how this has changed, and that's what I would intend to see happen with the trust that you contemplate here.
So the 468B trust really offers an opportunity for the practitioner who is never going to have the expertise to deal with these issues, to really bring in the professionals like yourself to work on these problems on the front end, yes, which you say will give a better chance of getting a better resolution for the client than leaving it to the end or doing it on their own.
Jan, I think it's the way of the future. I'm finally getting people from the plaintiff steering committees on contemporary mass torts that may be months, years away from settling, and they're realizing that we can go cut I don't want to say cut a deal, but we can form a model with the states and the federal government that says when these cases do settle, here's how we can fast track the resolution of liens. And so getting started early is the magic part of this, and knock on wood, we could get some of this done before the first settlement occurs.
Excellent. No, also, could you explain to the practitioner then the kinds of cases that they may have that you think would benefit from this approach?
Well, I think any mass tort, any product liability or pharmaceutical case could benefit from the modeling approach that we're talking about. But we also now do referrals on individual cases. Most people think of us in the mass tort context, but we're like any other practice. We've got all this skill, this expertise now, and we have all these talented resources in our offices, and we'll apply them to an individual case. And we have lawyers call us all the time now and say, I have an auto accident, and the state agency that is collecting for Medicaid, tort recovery unit, they want money back from when the guy went in because he had the flu or because he had an ingrown toenail or something ridiculous like that. And we're able to take our medical professionals, our billing and coding experts, and rip apart that lien and help them achieve resolution.
Now, I said at the outset you had a national practice, and I want to emphasize that point. Any lawyer in the country who has a problem that could benefit from this approach, they can contact you. You have the ability to able to provide services to any lawyer in the country.
Absolutely, and we'd be happy to work with any single practitioner, as you'd expect me to say, but most of our phones are ringing off the hook on individual Alborn allocations now, where we're actually helping people deal with their state agency on a single case, and so we'd be thrilled to work. And we've resolved liens on individual cases in all 50 states and territories now.
Well, I just want to, first of all, thank you, Matt, and I just want to say to our listeners that you are truly a pioneer and an innovator.
Thank you,
and I have been absolutely impressed of how you have developed this area that was completely underserved,
right.
And you have really established a standard of excellence, and every practitioner who has the chance or opportunity to use your services are going to be very well served. I want to thank you very much.
Thank you.
Take
I appreciate
care.
it.
Thanks,
Thanks, Jim.
Bye-bye.